We're live.
Good afternoon. This is the House Judiciary Committee. It's March the 10th, about 1:30. We have four 7 witnesses to testify today, or 4 bills to hear today. So we're going to get right into it. Delegate Grammer, House Bill 415. Joining you will be Stanford Frazier from the Office of the Public Defender, and then we'll hear the person in opposition. So go ahead, Delegate Grammer, for 3 minutes.
Thank you, Mr. Chair. For the record, Delegate Robin Grammer here to present House Bill 415. House Bill 415 protects the firearm ownership rights of Marylanders who are patients qualified to use medical cannabis. House Bill 415 limits the access to the database of qualified patients and codifies that a qualified patient may not be denied their right to purchase, own, possess, or carry a firearm based on their status as a qualified patient. Transactional firearm forms inquire about your status as a qualified patient. If you acknowledge in the affirmative as to your status as a legal user of medical cannabis in Maryland, you lose your rights to own a firearm. To be clear, it is not that you have ever possessed or purchased cannabis that disqualifies you. If you have a card, you lose your rights. Combat veteran Josh O'Neill testified that he carries a firearm as part of his employment and would like to use cannabis for pain management for combat-related injuries. Ironically, he works for the Maryland medical cannabis industry. He described his addiction to pain pills for 2 years and his recovery. I'm in horrible pain every day. I sleep about 2.5 hours every night. All I'm asking is to be able to sleep. What does it say when we force those who served our country in combat to choose between unemployment and non-addictive medical solutions or perjury? The commercial growth, distribution, and sale of cannabis in Maryland violates federal law. We sanction a federally illegal industry, but treat qualifying patients as second-class citizens. The denial of these rights is a violation of Maryland's General Health Article 13-3313A, which clearly states that a qualifying patient may not be denied any right or privilege for the medical use or possession of medical cannabis. Becoming a qualified patient makes you a person disqualified to own a firearm. This is not just an unfortunate loophole and inconvenience, but a statutorily defined status that makes you subject to arrest. This isn't hypothetical. Maryland State Police are currently actively pursuing the revocation of Marylanders' gun rights due to their status as a qualifying patient, including all the revocation of all their licenses and the confiscation of their firearms. Additionally, the Maryland State Police have pursued access to the database of qualified patients. This is an active situation that we should act to stop now. With that, I'll close and say we should pass House Bill 415 to protect the rights of those who choose non-addictive healthcare solutions. I ask for a favorable report, and I'd be happy to take questions.
Thank you very much. Here's what we're going to do. I don't believe that we don't have Stanford Frazier or the person who was going to testify in opposition to Delegate Grammer's bill. However, we do have Delegate Hornberger, who has a similar bill to Delegate Grammer in a slightly different posture. So we'll just hear from them separately, and let's just take questions for Delegate Grammer right now, and then we'll go to Delegate Hornberger. Any questions for Delegate Grammer? All right. Seeing none, that concludes the testimony for House Bill 415. We'll go to House Bill 543 now. This is Delegate Hornberger and his bill on the similar topic. So Delegate Hornberger, you have 3 minutes and you're the only person signed up to testify.
Great. Thank you so much, Mr. Chair and members of the committee. I have before you today HB 543, Firearms Right to Purchase, Possess, and Carry Use of Medical Cannabis. I think the committee will enjoy this bill because, frankly, it's so liberal, conservative, and it's so conservative, it's liberal. And I'll tell you why. Currently, we have folks who have been prescribed, have gone the legal route to seek out a medical cannabis card for a variety of ailments. It's a successful program. However, because this is a decision that the state has decided to take on, it's potentially run afoul of federal law. What do I mean by that? If you read the fiscal note, which is very short in its description, bill specifies that a person may not be denied the right to purchase, possess, carry a firearm solely on the basis of use of medical cannabis. We seek to repeal that and make it so that law-abiding citizens who wish to own a firearm can continue to do so. We don't feel that passage of this bill will incentivize people to buy firearms or that there will be more firearm use, but it will go a long way in reducing some of the fears that regular law-abiding citizens, everyday citizens have about continuing to exercise their constitutional rights. Over the interim, we were approached by a group in Prince George's County, because we followed this bill last year, that wanted to pursue a retail-based cannabis license, and they were afraid to do so because they possess firearms. The fines are pretty draconian. If you are caught breaking this, they can be as much as 10 years or a $250,000 fine or both. So some background on this bill: it did pass the Senate last year, and it's back in the same posture because we ran out of time. We'd ask that this committee move favorable on the bill, and happy to take any questions. Thank you, Mr. Chair.
Are there questions for Delegate Hornberger? Delegate Cox.
Thank you, Mr. Chair. Thank you, Delegate Hornberger and Delegate Grammer. Could you, Delegate, explain the difference between your bill and Delegate Grammer's?
So this bill that we have is basically just prevents you from being able to access the list and then use that against you. I believe I'll let Delegate Grammer speak to the differences on his.
Very briefly, didn't expect the question, but we actually had an Attorney General's opinion on the totality of the subject matter. I'd be very happy to share that with you. But my bill precludes access to the database, which the state police have been attempting to get at to use for law enforcement purposes. And it also in various ways protects, the requests to get to the database, requests for use of the information, as well as protecting the actual ownership rights of the firearms themselves. And I'll be happy to share a copy of that with you.
Yeah, and if I might add, Mr. Chair, I think that both, I can't speak for Delegate Grammer, but I think that if there was an effort of this committee to potentially merge both of these concepts because they are so similarly aligned, I don't think we'd have any opposition to that.
Are there further questions? All right, seeing none, thank you very much. Concludes the testimony on House Bill 543. We'll now,
Thanks so much.
thank you. We'll go to House Bill 1184. This is Delegate Cardin, and he has one person testifying with him, and that's Mark Stitchell, I think. Wait, I'm sorry, I'm supposed to take. All right,
You can take the other bill first.
Yeah, we need to take the other bill first. Okay.
That's fine.
Because he hasn't been able to get on, so we'll do that. We'll go to House Bill 1046 with Delegate Rosenberg, and he's the only person signed up to testify orally for that bill. Delegate Rosenberg for 3 minutes, please. Except you have to unmute yourself, Sandy.
You could get in as the poly line there, but you're not.
I didn't want to hit you with the Poly City thing. I'm about bringing people together,
Good for you.
Today, I am sunshine and light today. Totally. Absolutely, and nothing else,
I'm glad to hear it. Thank you.
Madam Vice Chair is laughing a little too hard, though. 3 minutes, Delegate. Go ahead.
Thank you, Mr. Chairman. House Bill 1046 would extend our existing law regarding impermissible traffic stops beyond race, where Maryland was one of the first, if not the first in the country, to put this policy into law, to prohibit other stops improperly based upon an immutable characteristic of an individual, specifically ethnicity, national origin, religion, gender identity, or sexual orientation. The idea for this bill came from 40 miles away, or it's less than 40 miles away here in Annapolis, from the Congress of the United States. Senator Cardin introduced such legislation at the federal level last year, and has reintroduced it this year. The George Floyd legislation that passed the House contains such a provision. And it is the expectation that the bill in the main Democratic bill in the Congress, in the Senate, will also include this provision adopted from Senator Cardin's bill. So I think we know as Marylanders the importance of training our officers not to make stops that are inappropriate based on a characteristic of the driver. This bill would extend that policy to categories of people who are already protected under our civil rights laws. So that's the basis for bringing those folks, those characteristics into this statute. And we would be, hopefully, with the passage of the legislation at the federal level, we would be in accord with what the federal government hopefully will be doing, but also in accord with a policy that we have established with our existing law, but only dealing with race. And the same reasons that justify training and what the other attributes that are associated with the existing law would apply to these additional categories as well. So I would move a favorable report and thank the committee for its consideration.
There are questions for Delegate Rosenberg. We'll go to Delegate Cardin.
Thank you, Mr. Chair. Thank you, Delegate Rosenberg, for bringing this bill. Is there any protected classes that are not included in this legislation?
Yeah, I believe I did not include disabled because I didn't think that would be a characteristic that would prompt law enforcement to, act improperly. But I am, if the committee's will, it is the committee's will as to, if you want additional groups.
And the reason I ask is because, first of all, I could think of scenarios, give a lawyer an opportunity to think of scenarios. We could think of scenarios for anything. A disabled person could certainly be pulled over, whether it be physical disabled or mental disability, because of a way that they look or a way that their car looks because of changes to the car based on that. But the reason is because we had a bill earlier this session, which we're still working on, or that's going through the Senate now, dealing with adding panic defense against people in a certain protected class. And I had made the suggestion that maybe we adopt whatever are the protected classes in the hate crime statute would be attached to the prohibition of that defense, because those classes may change. And then if they change, or there's additional classes that are added, you don't want to have to then go into the statute and re-enumerate. I'm just curious if that's something that you would consider. We can talk about it later. It's just a thought.
If it is the committee's will to broaden, I am fine with that. Absolutely. Thank you.
Are there further questions? All right, seeing none, thank you very much. That concludes the testimony on House Bill 1046. The last bill we have is House Bill 1184 and Delegate Cardin. Are we ready?
Thank you very much.
Yeah, so go ahead for 3 minutes.
Mr. Chair and members of the committee, thank you very much. I asked for a favorable report on House Bill 1184. This came from a constituent who is a judge who had recommended that we consider putting in legislation that would allow a judge to be able to remove personal information, identifying information from the public record for protection purposes. Delegate McComas actually had an analogous bill, although this is a little bit different. And basically, it allows the judge or another at-risk individual, as defined in the legislation, to bring an action for an injunction to remove personal information based on safety issues. This has been done in, I believe, North Carolina, and I believe that the federal government has been making moves to do this as well in federal courts, although I do not believe the legislation has actually passed, but it has been proposed. I consider our judges to be to be individuals who are constantly under attack by people, and to keep their personal information anonymous could allow them to be freer to make decisions that would be appropriate based on the case and not based on what they believe is in their own personal best interest. With me, I have Mr. Mark Stitchell, who, among other things, is the chair of the Sitting Judges Committee, I believe in Baltimore City, who has obviously close encounters with many judges and their families. I think he will bring a perspective that will be helpful.
Go ahead, Mr. Stitchell.
Good afternoon. First, I just want to make clear that I'm speaking here in my personal capacity, but as Delegate Cardin said, I have been the chairman of the Baltimore City Sitting Judges Committee since the 1990s. I also have another perspective on this issue, in that my father was a district court judge, and before that, a judge of the Municipal Court of Baltimore City, which was a predecessor court. And when my father was a judge and I was a child, we actually had a kidnap threat against my sister and me. Of course, that was a much more low-tech era. Someone put a note on my father's windshield and he was promptly identified, and I think he was relatively harmless. But it did bring a great deal of anxiety to our family while that was happening. This bill is patterned on a bill which was enacted in New Jersey last year in reaction to an attack on the family of Judge Esther Salas, who is a judge of the United States District Court for the District of New Jersey. Someone came to her house and shot and killed her son and killed her husband. This is not the first attack on a federal judge or a state court judge. And given the availability of information about judges' residences and other such things, legislation like this is very important. And I urge the committee to recommend its passage.
Are there questions for the panel? Delegate Cox.
Thank you, Mr. Chair. Real quickly, Delegate Cardin, thank you. I think it's a great bill. Just a question on page 5, line 16, says that they'll have to also redact or eliminate the name and location of an employer. Assuming that would include the courts, how does that work, since the federal courts and the state courts list the judges on the website of those respective courts?
So, right. So I think that is pertaining, it is intended to pertain to family members. It would be obvious that these courts are, that the judges are employed by the courts. So redacting that would be useless. But that information. But for a husband of a judge or a child of a judge who, you find out that the husband of a judge works, for example, as a clerk or as a tech at a hospital, and you can go into that hospital, find that person and threaten them. That would be the idea.
I guess I'll talk offline on that, because I see on page 4, line 22, it seems to include both, but I'll talk to you offline on that.
I understand that. I'm saying that I think that I think it would be, it doesn't matter. It's whether you redact it or not, they're going to know that they're a judge of that court. So I think you're right, but I don't think that it makes a difference either way.
Right, the Vice Chair.
Thank you, Mr. Chair. Just a quick question for Delegate Cardin. I mean, have you thought about including members of the General Assembly in this? I mean, I get, all types of interesting things related to certain legislation that I propose.
As do I.
So just
Just to give, so back in 2004, I got, when we were doing, I got based on legislation that I was going to vote in favor of. Actually had to have a security detail per the instructions of the speaker back then, because I showed the Sergeant at Arms, Larry Barnes, the emails that I was getting, and the speaker asked me to do that, and until after the vote on that particular legislation.
Yeah, I know.
The answer is that is really, I mean, I'll say the same thing that Delegate Rosenberg said. The committee thinks that that's appropriate. I think that we as legislators know we're in a different situation where we are putting in stuff on our own volition, that we are aware of the consequences perhaps of our actions, and we can we deal with that as legislators, whereas judges are assigned cases of a murder or an alleged murder, and there's oftentimes intimidation there that they can't foresee. So I would say it's something we could consider if it's the will of the committee, but I think that you're talking about sort of not necessarily apples and oranges, but maybe apples and kumquats, sort of oranges, but not quite oranges.
Thank you.
Delegate Ron Watson.
Thank you, Mr. Chair. And Delegate Cardin, my question is along the same lines as the Vice Chair. I mean, it talks about at-risk individuals, and by Maryland State Police standards, we are all in an assumed risk position here in the General Assembly. And, you know, one could argue, as you said, we go on our own volition, but more likely we're going on the volition of subsets of our community to put legislation in place that impacts them. And so I would also argue that I think members of the General Assembly fall right under here. And as much as I love our judges and they need protection, I would also love to participate and be able to have these protections in place for my own personal protection as well. So I ask you to consider that. I think it's appropriate. Sure. I'm all, look, it's the will of the committee. This, as I've always said, that once the bill goes to the committee, it's the committee's will. If you think you want to expand it, I'm not against that. I think that makes it a little bit a slightly different bill, because there are different reasons why you are and rationales as to why legislators would want to have their personal information redacted, and some legislators may not want to. And actually, the way this bill is drafted is you're not required to do it. It's upon request of the individual that it can be done. So, and by the way, the fiscal note says that it can all be done under existing resources. So I don't think it's going to cost anything, regardless of what we do. But I think that at the bare minimum, judges happen to, by no fault of their own, by the work that they do, and the decisions of integrity that they make oftentimes are put in positions where their family members are at risk. And if we think we are too, maybe that's a decision we make, and that's the will of the committee. Thank you.
Are there further questions? Seeing none, we thank you very much. And that concludes the testimony for House Bill 1184, and that concludes the testimony for today's bills. Committee, we have the following coming up. We have 2:30, the Civil Law Subcommittee will be meeting. At 5:30, we'll be going back to our floor session tonight. 8 o'clock, I'm going to ask the subcommittee chairs to gather for a meeting. The Criminal Law Subcommittee will be meeting tomorrow at 1, and a likely vote session tomorrow at 3 p.m. Our next bill hearings are on Monday at 1:30 p.m. They're going to be sponsor-only bill hearings, bills that were released from the Rules Committee on Monday at 1:30. So we do not have bill hearings tomorrow, do not have bill hearings on Friday. So thank you all very much for your attention today, and we are adjourned. Thank you very much.